When you start your preparing for your commercial and agency law exams, it is very important that you take into consideration that you're not required to study everything you have covered with the course, but only what is required for the exam, what is the most important to focus on for your exam purposes. So it's not about working hard. It's not about trying to read everything that you have covered on the course and studying absolutely every course material and every lecture. It's about working smart. What does it mean to work smart? A student who wants to get a first class should create a very detailed and well thought out study plan that contains the list of topics that are very important to focus on for the exam purposes. So how you do that, you analyze your exam requirements. What is your exam exactly? Is it a coursework or is it an online exam? Are you able to open the book on your exam? If yes, then that's easier. If not, then you should really focus on memorizing the cases and memorizing the principles. If you can open the book, you should focus on highlighting what is important for your exam so that you have it in front of you. So depending on what you're allowed to do on the exam and what your exam actually requires, your study plan has to be organized that way. I can understand that it can be very difficult for you to organize your study plan and plan very, very well how your revision should be and how you should be preparing for your exam. And if that's the case and you need some help on that, we can help you with that. You can book a tutoring session, one-to-one tutoring session, and we can help you create a perfect plan for tailored for your own exams. In this case, in commercial and law exams, we're going to analyze an example of having 6 questions on the exam, out of which you should answer 3. So what are the most important topics for commercial and law, commercial and agency law? Sale of Goods Act 1979 very often come up as a problem question in commercial law exams. Also, ownership and NEMO principles are very important to know. International sale of goods agency. These are all the topics that may come up as a problem or essay question. So it's very, very important that you practice answering both essay and problem questions on these topics. Where do you find the practice questions to answer? You can find it on our website. If you go to commercial and agency law and model essays, you will find the questions that you should be practicing with. And how do you do that? You just read the question, try to answer it, draft an answer, and then you compare your answer to our answer there. Also, you should download past exam papers from your university's website model, and you should practice with that. If you practice with your past exam papers, so you're very well prepared to answer the exam that the students in your university got last year, you should be very well prepared to answer your exam as well. So make sure that you practice as much as possible from both past exam papers and our model essays. It would be the best practice if you also get a few tutoring sessions with us for us to review your practice answers and advise you on how to improve your legal writing skills. Legal writing skills is not something you can learn in a day or two. It requires a lot of practice. So that's why it's so important that you practice answering problem and essay questions as much as you can, and you get some feedback and guidance on it. So that's where our tutoring sessions come in. Obviously, you can get guidance from your professor, and we highly recommend you to do that. More feedback you get from your professor, the better it is. But most of the time, the professors don't have that much time to approach each student individually and give detailed feedback. So that's why our tutoring session comes in very handy in this kind of situations. How do you answer a problem question? Overall structure for answering a problem question is the following: issue, rule, application, conclusion. It's very important that you identify all the legal issues that arise in the problem question. You put a statement of the legal issue, then applicable law, and then you apply the law to the facts of the case of the problem question, and you make analysis, you make arguments to convince the examiner about what you're saying. So if it's like if you were a lawyer and you argue your case and you have to convince the judge and that your client should get the remedy that you want your client to get. So that's what the analysis is. You have to make sure that your arguments are convincing, that your arguments make sense legally, and are very strong. How you do that, all that strong legal writing skills come from practice. So it's highly recommended that you practice as much as possible, get feedback from your professor as well as us. In the conclusion, after providing the analysis, you need to conclude what would be the most likely outcome of the legal issue that you have discussed if this case went to the court. Essay question style is a bit different how you answer an essay question. You also have a statement, you may have a statement of the legal issue. You have to identify the relevant laws, and instead of application of the relevant laws to the facts of the case, you refer back to the question and make an argument to answer the question asked. In the conclusion, you conclude your argument and you make sure that you make sure that your argument is clear for the examiner. Sale of Goods Act. Make sure that after this session you read our notes on Sale of Goods Act that is here. And what is the key principles that you need to know about Sale of Goods Act. Section 13, 14, and 15 is the most important principles you need to know. These are implied terms in every commercial contract of sale of goods. Section 13, where there is a contract for the sale of goods by description, there is an implied term that the goods will correspond to the description. What is sale by description and which word should be treated as part of the description? This is the case that you can read on that. And we can have a look at that case. So in this case, both the defendant and the plaintiff were art dealers, and the defendant was asked to sell 2 oil paintings which had been described in a 1980 catalog. And I'm going to share my screen so that you can see it. So the defendant contacted the plaintiff here, amongst others, and an employee of the plaintiff visited the doctor's gallery, the defendant's gallery. Mr. Hall, for the seller, made it clear that he was not an expert in German expressionist paintings, but plaintiffs still bought the painting for 6K. Was it breach of Section 13? It was argued that it was not. The principal test that was applied for deciding whether or not it was a breach of Section 13 was one of reliance. It was argued that the paintings are often accompanied by views as to their provenance, and this does not mean that it's a sale by description. Accordingly, the question to the court was whether the buyer has relied on the seller's statement before deciding to treat the statement as part of the description. As a result, as the contribution was only the piece of potential descriptive labeling attached to the painting, the Court of Appeal held that it was not a sale by description. So we have to analyze how much of reliance has been put by the buyer on the seller's description. In case of art, it turned out that the court was of the opinion that with the reliance was not that great for Section 13 to apply in this case. Section 14 is when the seller sells goods in the course of a business, there is an implied term that the goods supplied under the contract are of satisfactory quality. There are exceptions to Section 14, and if you read the Section 14 carefully, you'll be able to understand the exceptions, and you're highly recommended that you understand the exceptions. For example, one of the exceptions of Section 14 is that if any of the fault of the good being sold under the contract was brought to the attention of the buyer before the sale was concluded, then Section 14 will not apply. For example, you're buying a car and the car has a problem. I don't know, maybe the engine is not working properly, and you were aware of this problem because the seller told you, and you still buy it. You cannot later bring a claim against the seller arguing that Section 14 was broken and argue for some breach of contract because the seller already told you about the fault. And yes, it was not of satisfactory quality, but you agreed to it and probably you got a discount for it. So Section 14 only applies when you were not aware of anything that renders the good sold unsatisfactory. The third, Section 15, a contract of sale is a contract for sale by sample where there is an express or implied term to that effect in the contract. So this is where the goods are sold by sample. For example, you are given a bag and you're told that you're going to receive 30 bags just like this one, which is the sale by sample. What are the rights and remedies of parties whose Section 13, 14, and 15 rights have been broken? Firstly, buyer's rights is repudiation, rejection, or repudiation. So rejection is a mere termination of a contract. You reject the goods to be received, and as a result, you can get a refund. If on the arrival it turns out that either quality or quantity does not match to what was agreed in the contract, you can reject the goods. However, the buyer in the similar situation may want to have other remedies rather than reject completely the delivery of the goods. For instance, the buyer may want to keep the goods, but for the lower price. So rejection is just one of the remedies, in which case you just terminate the contract. Headley versus Baxendale. It was argued that only forcible damages to the goods are recoverable. In the case of Cullinan, the principle that came out of it is that one must choose between claim of loss of profit and claim of loss of expenditure. The innocent party cannot claim for both. So in the case of commercial contracts, when the goods delivered are faulty and one of the innocent party suffers loss, they can make a claim for loss of profit or loss of expenditure, not both of them. So these are just one of the remedies that an innocent party in commercial contract can pursue. In the exam question, you can advise to the innocent party who has lost profit due to wrongdoing to claim wasted expenditure rather than loss of profit, because it's easier to prove. It would be much harder to provide convincing evidence for a hypothetical situation of how much would be the loss of profit had the wrong act not taken place. The loss of expenditure would be easier to prove. A problem question, Tracy, a buyer. This is just an example of problem question that we can read now and see how we can answer it. Tracy, a buyer for Wonder Watches Ltd, a designer watch outlet registered in England, visits the London office of an Italian wholesale supplier of watches. At Magnifici Orologi, the manager, Ashley, shows Tracy numerous models of the newest Italian designer watches. Based on their appearance and style, Tracy agrees to order 7,500 watches. Ashley guarantees Tracy that her customers will be very happy when they buy the watches. Ashley adds that the watches are second to none. The goods are to be delivered to Wonder Watches Ltd by 1st of June. Tracy pays Ashley the total amount for the watches. The watches arrive 11 days late and made with low quality materials. How do we advise the party? Innocent party here. Tracy Firstly, we have to start with the issue. We make sure that the examiner is clear about what is the legal issue that we are addressing. Then we identify the relevant law and provide analysis. Tracy is a designer acting for Wonder Watches Ltd. She buys the watches from the supplier. As a result, this is a business-to-business transaction, and sale of goods Act 1979 applies. We have to first identify whether it's a B2B transaction or B2C, because different acts apply for each. If it's a B2B transaction, Sale of Goods Act apply. If it's a B2C transaction, Consumer Rights Act 2015 applies. Although the terms of the statute are quite similar, especially about section 13, 14, and 15, it's still a different act, and we have to identify which one applies in this situation. In the B2B transactions, there are two parties, the seller and the buyer. The seller is defined under section 61 of the SGA, and it means a person who sells or agrees to sell the goods. Here, actually, is the manager and makes a sale on behalf of the company. As a result, the seller here is the company. So we now solved two legal issues. Firstly, which act applies in this situation and why? And secondly, who is a seller? And we defined under section SGA, who is a seller, what is the seller's description, what is legal definition of a seller, and we applied it to the facts, and we said that Magnifici Orologi is a seller. Moreover, section 61 defines buyer as a person who buys or agrees to buy the goods. In this case, Tracy, who is a designer at Wonder Watches Ltd, buys the goods. Therefore, the company itself, Wonder Watches Ltd, is the buyer. Issue 2 is this breach of section 13. The first issue that arises is that Ashley, who acts for the seller company, assures the buyer that the watches are of the second to none and shows Tracy several models of it. Section 13 states that where there is a contract for the sale of goods by description, there is an implied term that the goods will correspond with the description. So as you can see, the first sentence here was the statement of the issue. This is the legal issue here that we're addressing. The relevant law, section 13. Then we have to provide any other relevant law that it applies here and provide analysis. This condition cannot be excluded from any commercial contract as stated in section 618 of the Unfair Contract Terms Act. So even if there was exclusion clause in the contract excluding section 13, that's not legal under ACTA. However, not all words which could be regarded as words of description will be treated as part of the description of the goods for the purposes of section 13. The test was identified in the case of Harlington versus Christopher Hall Fine Art to be the following: whether or not the buyer has relied on the seller's statement before deciding to treat the statement as part of the description. Nevertheless, in some cases, courts have taken very strict views as to what is a description. In Ashington Pigris versus Christopher Hill, the House of Lords held that the words fair, average, quality was not part of the description because these words were not needed to identify the goods. So now we're discussing the relevant law to say, to conclude whether or not here this was a sale by description. Therefore, the key requirement to show for section 13 is the reliance that the words are used to identify the goods in question. In this case, decided to buy the watches based on the way they look and feel, ordered 7,500 watches, applying the test of Harlington. The buyer did not rely on the seller's statement that the goods were second to none in order to make the decision to purchase it. Moreover, according to Christopher Hill principle, the words that the watches were second to none were not used to identify the goods. Accordingly, it can be argued that it's less likely that the court finds the breach of section 13 on these facts. You can read the full essay here. There are other legal issues that arises in the problem question, and we only dealt with the first part of the essay. The application of other principles under the SGA is in the essay that you can read at this link. You will receive the slides after this session, and you will be able to go to the relevant links. Now we will briefly discuss what is ownership in modern principle. The brief notes in this case on these principles can be found at this link. To transfer ownership of the goods from the seller to buyer, Section 12 applies. It says right to sell, but it does not cover the transfer of ownership. In most cases, the seller will be entitled to sell, either because he or she is the owner or agent of the owner. Classification of goods is sometimes a legal issue that should be discussed in ownership problem questions. So make sure that you're aware of these principles. Existing goods, SGA section 5.1, future goods, agreement to sell. So basically in this case, you need to identify whether or not it's the sale of contract. The contract is about sale of existing goods or sale of future goods. It makes a difference. And the difference is identified in section 5 of the SGA. Also, we have something called specific goods. If the goods are identified and agreed upon at the time of the contract, they are specific goods. And we have uncertain goods. If they are not identified at the time of the contract, they are considered as uncertain goods. These are the kind of problem questions that you will receive on ownership, and make sure that you're familiar with these concepts. When does the property pass from the seller to the buyer? Specific goods, when parties intend it to pass. Section 17, Section 16, and Section 18 rules apply. We have a model answer on Section 16, 17, and 18. Make sure you read that now, because it's very important for you to know how to answer a problem question on this topic. Finally, international sale of goods. It also very often comes up as a problem question in the commercial law exams, and make sure that you know what is it and how the laws work around this topic. Especially, we need to be aware of FOB and CIF contracts, which are the most examinable topics. What is FOB contract? Under FOB contract, the seller is responsible for placing the goods on board the ship and for paying all charges up to the point that the goods are placed on the board of a nominated vessel. So here the seller has to basically place the goods on the board and has to pay for charges up to that point. And the buyer bears the risk of loss or damage to the goods from this point and the cost of the carriage. This term requires the seller to clear the goods to export. Performance on part of the seller is completed when the goods are placed on board the nominated vessel, and risk and property passes to the buyer. So in FOB contracts, the seller is out of the picture once the goods are delivered in the port. In the nominated port from where the goods have to be shipped. So then it's the responsibility of the buyer. How does that work? They usually purchase an insurance, and the insurance actually insures the goods. And if the goods are lost during the carriage, or if something happens, then the insurance will be liable, but not the seller. The seller is out of the picture once the goods are delivered in the nominated port. What is CIF contract and what's the difference? CIF contract is also known as all-inclusive contract. Here the seller plays more role than in FOB contracts. So here, the seller is to arrange and pay for both the contract of carriage and insurance of the goods. He must produce a sale invoice, insurance policy, and claim of bill of lading. The seller must clear the goods for export, whereas for FOB contracts, the seller is out of picture quite soon and is not paying for insurance and is not paying for contract of carriage and so on. So the CIF is basically all-inclusive contract. The buyer is not doing anything here, just accepting the documents from the seller under CIF contract. The documents that the buyer has to accept is obviously bill of lading, sale invoice, insurance policy. The seller's remedies here are non-payment of the goods. When goods have passed the ship's rail, whereby property and risk also passes to the buyer, the seller may sue the buyer for non-payment of the goods, damages from non-acceptance, and breach of warranty. These are the available remedies for seller and if the buyer breaches the contract. Finally, agency also often come up as a problem question in commercial agency law exams. It can also come up as an essay question. Make sure that you have a look at possible essay questions you can get in agency and practice on that. What is agency? There are three parties you need to be aware of: principal, agent, third party. Principal instructs agent to act in the purchase of sale of goods from or to the third party. The contract of sale that arises is enforceable between the principal and the third party. Agent has no liability to either principal or the third party on that contract. Agents may be created in different ways by express or implied agreement. It can be created by representation by the principal, or agent can have an authority by contract. A principal can ratify an act without authorization purported to undertake that act as an agent of the principal. So principal basically can ratify the act of the agent even if he hasn't had the power to do so specifically, and it can also be agency by necessity. So once you have agency problem question, make sure that you identify who is the agent, who is the principal, who is the third party in the problem question. Make sure you identify that there is a valid agency created, and by identifying whether or not there is a valid agency created, you need to show how was the agency created, and was it valid? So was it created by express or implied agreement, or representation by the principal, or ratified act, or whatever the way agency was created? Make sure that you discuss that. Here are the important cases to read on this topic, and make sure you have a look at these cases after the session. So to sum up, you need to analyze your exam requirements and create a perfect study plan tailored to your specific exams. How you do that, you analyze your the exam. Are you going to have a coursework? Are you going to have an exam? How many questions do you have to answer? What kind of questions are you going to get? Are you going to have a book on the exam, or are you allowed to have notes? So all this you have to take into consideration when you create your study plan, and then plan very, very smartly how to get a high grade. Basically have a study plan that maximizes your chances of getting a high grade. We help students for doing that. We have helped lots of students to create their perfect study plans and improve their legal writing skills. So if you're not sure how to do that and how to maximize your chance of getting a first class for your January exams, make sure you book a tutoring session with us. You should do it selective studying. It's not recommended you to read absolutely everything that your professor has mentioned throughout your course, because that can be a lot, that can be confusing. Make sure that you focus your attention on what matters. So that's why we have created our website, which focuses on the topics and just the information, just the right information you need to maximize your chances of getting a first class. How we do that? People who create our content and makes it available for you on our platform are top students and graduates. They have been in your shoes and they have done it. They have gotten high grades, and they know very well what to focus on exactly to maximize your chances of getting a first class. And it's a great material to have a look and to study with. Thirdly, you need to practice answering problem and essay questions, because knowing the right information is great, but it's only 50% of the work. You really need to have a very good legal writing skills. And how you get that, this is not something you learn in a day or two. You have to practice as much as possible. And how you practice by answering problem and essay questions from our model essays, from your past exam papers, an informative coursework your university may have given you. Basically any or even tutorial questions from your university, you need to answer as much as possible. Get some feedback from your professor as much as you can. Make sure you follow that, because grading is subjective. Every professor may have their own requirements, although there is a universal set of grading, but some professors may want you to focus on specific cases or specific principles, or they may want to follow a specific plan. So make sure that you understand what your professor wants from you, and then integrate that in your legal writing skills, and make sure that you answer the questions on your exam the way your professor wants to. And you should get tutoring sessions to get some help on that, so that you are prepared and you are at a very good position to answer your exam questions and get a high grade. How can we help? As I have already mentioned, our content creators are top law students and graduates who have been in your shoes and gotten high grades, and all our platform, all the content on our platform is basically focused on to get you high grades as simply as possible. Our simple study resources include simple notes, model essays, tutorial videos, quizzes, flashcards, exam tips, and study groups you can join for free. If the resources are not enough, you're highly encouraged to book some tutoring sessions so that you improve your legal writing skills and you get a perfect study plan tailored to your needs and to your exams. We have already helped thousands of law students to get a first class, and we have, according to our research, 90% of our regular users get a first class. So you're highly encouraged to regularly use our platform and regularly use our premium content to maximize your chances of getting a first class. We would love you to be our next student to get a first class, and please join Simple Study now. Thank you very much for your time. I will be glad to answer your questions. If you have any questions, you can put it in chat, or you can unmute your microphone and ask your question. Thank you.